child support automatically abated in Oklahoma for inmates. I'm Tulsa Attorney James Worth, and we're talking about a very significant change in the Oklahoma child support guidelines. It's part of Senate Bill 421 that went into effect as law on November 1st of 2021. It has a number of changes related to the Oklahoma child support guidelines, the most significant of which is the abatement of child support for those incarcerated for 180 days or more. And what it indicates in the law is it says, after November 1st of 2021, there shall be a rebuttable presumption that an obligor who is incarcerated for a period of 180 days or more consecutive days is unable to pay child support. So it starts with a presumption that they cannot pay child support or unable to pay child support. And then it notes that the obligor's child support obligation shall be abated without court action effective the first day of the month following the entry into the correctional facility. Now, it doesn't even have to be necessarily in Oklahoma. It could be, county jail, state penitentiary, federal, could be in this state, another state. If the order is out of Oklahoma and is being enforced in Oklahoma, and that person is incarcerated, regardless of where they're incarcerated, if they're incarcerated on November 1st of 2021 or after, and their incarceration is for 180 days or more, then the child support is automatically abated without going to court, without making the request, starting the first of the month after the incarceration. And then after they are released, the abatement automatically ends the first of the month after a 90-day grace period from getting out of custody. So during that time period, no new child support is ordered. The old child support is still in place and not effective prior to the date that it's abated. But all of that for the time period that they're in custody, and for 90-day grace period afterwards, they're accruing no new child support. However, that is just a rebuttable presumption. It does happen automatically without going to court. However, the other side could file and try to rebut that presumption. If they have earning capacity while they're incarcerated, or they have assets and ability to pay, then they can file to rebut that presumption to keep that child support order in place while they are incarcerated. This could be, very significant, a lot amount of money that could be at stake for some people that are receiving child support, some people that are owed child support here. Certainly in the cases that I've handled at my office, this is something that's come up on a somewhat regular basis where an obligor may be in custody. So that's going to have an effect on a fair amount of people in the state of Oklahoma. It should be noted there is an exception, though. This does not apply where the person is in jail, is incarcerated due to a failure to pay child support. If it's a child support contempt, then it's not going to be applicable there. Of course, child support contempt is a misdemeanor with up to 6 months in prison, so I don't know how you'd get beyond the 100 days anyway, but that's noted in this statute as an exception. But there's also the felony crime of omission to pay child support. If the person is in custody for that basis, then the abatement does not apply. Also, where the child was a victim of the crime, then that appears to be a exception in the statute. So if somebody served jail time prior to, they completed their sentence of incarceration in custody time prior to November 1st, it's not going to change anything for you at all. If somebody is currently incarcerated but getting ready to be released, the statute's not completely clear, but it looks like the DHS at least is interpreting that as meaning as long as you were in custody on November 1st or after, that it is applicable to you and can go back and abate time periods historically starting the day after you went, or the first of the month after you went into custody. So if you have any questions about how this may affect your circumstances, talking about filing to rebut that presumption, or to make sure that this applies to your circumstances to lower your child support obligation, you're going to want to talk to an attorney about that privately, confidentially. To get that scheduled with somebody at my office, you can go online to makelawEasy.com.